Effect and application of laws, Civil Code. Q. If a will is executed by a testator who is a Filipino citizen, what law will govern if the will is executed in the Philippines? What law will govern if the will is executed in another country? Explain your answers. Number 2. If a will is executed by a foreigner, for instance, by a Japanese residing in the Philippines, what law will govern if the will is executed in the Philippines? And what law will govern if the will is executed in Japan or some other country, for instance, the USA? Explain your answers. Answer. Letter A. If the testator who is a Filipino citizen executes his will in the Philippines, the Filipino law will govern the formalities. B. If said Filipino testator is a foreigner executes his will in another country, the law of the country where he may be or Philippine law will govern the formalities. Article 815 Civil Code. Number 2. A. If the testator is a foreigner residing in the Philippines and he executes his will in the Philippines, the law of the country of which he is a citizen or Philippine law will govern the formalities. B. If the testator is a foreigner and executes his will in a foreign country, the law of his place of residence or the law of the country of which he is a citizen or the law of the place of execution or Philippine law will govern the formalities. Article 17, 816, 817 of Civil Code. Q. Jacob, a Swiss national, married Lourdes, a Filipina, in Bern, Switzerland. 3 years later, the couple decided to reside in the Philippines. Jacob subsequently acquired several properties in the Philippines with the money he inherited from his parents. 40 years later, Jacob died intestate and is survived by several legitimate children and duly recognized illegitimate daughter, Jane, all residing in the Philippines. Suppose that Swiss law does not allow illegitimate children to inherit. Can Jane, who is a recognized illegitimate child, inherit part of the properties of Jacob under Philippine law? Assuming that Jacob executed a will leaving certain properties to Jane as her legitimate in accordance with the law of succession in the Philippines, will such testamentary disposition be valid? Answer. Yes. As stated in the problem, Swiss law does not allow illegitimate children to inherit. Hence, Jane cannot inherit the property of Jacob under Philippine law. B. The testamentary disposition will not be valid if it would contravene Swiss law. Otherwise, the disposition would be valid. Unless the Swiss law is proved, it would be presumed to be the same as the Philippine law, under the doctrine of processual presumption. Q. The Japan Airlines, JAL, a foreign corporation licensed to do business in the Philippines, executed in Manila a contract of employment with Marites Guapa, under which the latter was hired as a stewardess on the aircraft flying the Manila-Japan-Manila route. The contract specifically provides that 1. The duration of the contract shall be 2 years. Number 2. Notwithstanding the above duration, JAL may terminate the agreement at any time by giving her notice in writing 10 days in advance. And 3. The contract shall be construed as governed under and by the laws of Japan, and only the court in Tokyo, Japan, shall have the jurisdiction to consider any matter arising from or relating to the contract. JL dismissed Marites on the 4th month of her employment without giving her due notice. Marites then filed a complaint with the labor arbiter for reinstatement, back wages, and damages. The lawyer of JL contends that neither the labor arbiter nor any other agency or court in the Philippines has jurisdiction over the case in view of the above provision. 3. Of the contract which Marites voluntarily signed. The contract is the law between her and JL. Decide the issue. Letter B. Where under a state-owned conflicts rule, the domestic law of another state should apply, may the courts of the former nevertheless refuse to apply the latter? If so, under what circumstance? Answer. Labor legislations are generally intended as expressions of public policy and employer-employee relations. The contract, therefore, between JAL and Marites may apply only to the extent that its provisions are not inconsistent with Philippine labor laws intended particularly to protect employees. Under the circumstances, the dismissal of Marites without complying with Philippine labor law would be invalid, and any stipulation in the contract to the contrary is considered void. Since the law of the form, in this case, is the Philippine law, the issue should be resolved in accordance with Philippine law. Letter B. The third paragraph of Article 17 of the Civil Code provides that prohibitive laws concerning persons, their acts, or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in a foreign country. Accordingly, a state-owned conflict of laws rule may exceptionally be inapplicable given public policy considerations by the law of the forum. Going into the specific provisions of the contract in question, I would rule as follows. 1. The duration of the contract is not opposed to the Philippine law, and it can therefore be valid as stipulated. Number 2. The second provision, to the effect that notwithstanding duration, JAL may terminate employment, is invalid, being inconsistent with our labor laws. Number 3. That the contract shall be construed as governed under and by the laws of Japan, and only the courts of Tokyo, Japan shall have jurisdiction, is invalid as clearly opposed to the four-sided third paragraph of Article 17 and 1700 of the Civil Code, which provides, Article 1700, the relations between capital and labor are not merely contractual. They are so impressed with public interest that labor contracts must yield to the common good. Therefore, such contracts are subject to the special laws on labor unions, collective bargaining, strikes and lockouts, closed shop, wages, working conditions, hours of labor, and similar subjects. Q. X and Y entered into a contract in Australia, whereby it was agreed that X would build a commercial building for Y in the Philippines, and in payment for the construction, Y will transfer and convey his cattle ranch located in the United States in favor of X. What law would govern? A. The validity of the contract. B. The performance of the contract. C. The consideration of the contract. Answer. The validity of the contract will be governed by the Australian law, because the validity refers to the element of the making of the contract in this case. B. The performance will be governed by the law of the Philippines where the contract is to be performed. C. The consideration will be governed by the law of the United States where the ranch is located. Q. A. A Filipino executed a will in Kuwait while there as a contract worker. Assume that under the laws of Kuwait, it is enough that the testator affix his signature in the presence of two witnesses and that the will need not be acknowledged before a notary public. May the will be probated in the Philippines? A. Yes, under Article 815 and 17 of the Civil Code, the formality of the execution of a will is governed by the law of the place of execution. If the will was executed with the formalities prescribed by the laws of Kuwait and valid there, as such, the will is valid and may be probated in the Philippines. Q. While in Afghanistan, a Japanese by the name of Sato sold to Ramoncito, a Filipino, a parcel of land situated in the Philippines, which Sato inherited from his Filipino mother. What law governs the formality in the execution of the contract of sale? Explain your answer and give its legal basis. Number 2. What law governs the capacity of the Japanese to sell the land? What law governs the capacity of the Filipino to buy the land? Explain your answer with legal basis. A. Number 1. Under Article 16, Paragraph 1 of the new Civil Code, real property is subject to the law of the country where it is situated. Since the property is situated in the Philippines, Philippine law applies. The rule of lex re site in Article 16 prevails over lex loci contractus in Article 17 of the NCC. Number 2. Japanese law governs the capacity of the Japanese to sell the land, being his personal law, on the basis of an interpretation of Article 15 NCC. Number 3. Philippine law governs the capacity of the Filipino to buy the land. In addition to the principle of lex re site, given above, Article 15 of the NCC specifically provides that Philippine laws relating to legal capacity of persons are binding upon citizens of the Philippines no matter where they are. Q. On 8 December 1991, Vanessa purchased from the Manila office of EuroAir an airline ticket for its flight number 710 from Dallas to Chicago on 16 January 1992. Her flight reservation was confirmed. On her scheduled departure, Vanessa checked in on time at the Dallas airport. However, at the check-in counter, she discovered that she was waitlisted with some other passengers because of international overbooking. EuroAir policy and practice. EuroAir admitted that Vanessa was not advised of such policy when she purchased her ticket. Vanessa was only able to fly 2 days later by taking another airline. Vanessa sued EuroAir in Manila for breach of contract and damages. Euroair claimed that it cannot be held liable for damages because its practice of overbooking passengers was allowed by the U.S. Code of Federal Regulations. Vanessa, on the other hand, contended that assuming that U.S. Code of Federal Regulations allowed intentional overbooking, the airline company cannot invoke the U.S. Code on the ground that the ticket was purchased in Manila. Hence, Philippine law should apply, under which Vanessa can recover damages for breach of contract of carriage. Decide, discuss fully. Answer. Vanessa can recover damages under Philippine law for breach of contract of carriage. Philippine law should govern as the law of the place where the plane tickets were bought and the contract of carriage was executed. In Salamea versus Court of Appeals, the Supreme Court applied Philippine law in recovery of damages for breach of contract of carriage for the reason that it is the law of the place where the contract was executed. Q. Michelle, the French daughter of Penrich, a German national, died in Spain, leaving real properties in the Philippines as well as valuable personal properties in Germany. What law determines who shall succeed the deceased? Explain your answer and give its legal basis. Number 2. What law regulates the distribution of the real properties in the Philippines? Explain your answer. Number 3. What law governs the distribution of his personal properties in Germany? Answer of number 1. The national law of the dissident French law shall govern in determining who will succeed to his estate. The legal basis is Article 16, Paragraph 2, NCC. Number 2. The distribution of the real properties in the Philippines shall be governed by the French law. The legal basis is Article 16, NCC. Number 3. The distribution of the personal properties in Germany shall be governed by French law. The legal basis is Article 16, NCC. Q. Alma was hired as a domestic helper in Hong Kong by the Dragon Services Limited through its local agent. She executed a standard employment contract designed by the Philippine Overseas Worker Administration (POEA) for overseas Filipino workers. It provided for her employment for 1 year at a salary of $1,000 a month. It was submitted to and approved by the POEA. However, when she arrived in Hong Kong, she was asked to sign another contract by Dragon Services Limited, which reduced her salary to only $600 a month. Having no other choice, Alma signed the contract, but when she returned to the Philippines, she demanded payment of the salary differential of $400 a month. Both Dragon Services Limited and its local agent claim that the second contract is valid under the laws of Hong Kong and therefore binding on Alma. Is their claim correct? Explain. Answer. Their claim is not correct. A contract is the law between the parties, but the law can disregard the contract if it is contrary to public policy. The provision of the 1987 Constitution on the Protection of Labor and Social Justice, Section 10, Article 2, embody public policy of the Philippines, since the application of Hong Kong law in this case is in violation of that public policy. The application shall be disregarded by our courts. Catalin versus POEA. Q. In 1977, Mario and Clara, both Filipino citizens, were married in the Philippines. 3 years later, they went to the United States of America and established their residence in San Francisco, California. In 1987, the couple applied for and were granted U.S. citizenship. In 1989, Mario, claiming to have been abandoned by Clara, was able to secure a decree of divorce in Reno, Nevada, USA. In 1990, Mario returned to the Philippines and married Juana, who knew well Mario's past life. Is the marriage between Mario and Juana valid? Would the Renwa Doctrine have any relevance to the case? Answer. Yes. In relation to Article 15 of the Civil Code, conflict of laws provides that the recognition of an absolute divorce granted in another state rests on the citizenship of the parties at the time the divorce was granted. Applied in this case, the divorce decree issued to Clara and Mario will be recognized as valid here, considering that at the time the foreign decree was granted, both Clara and Mario are citizens of the USA, a country which allows absolute divorce. Since the marriage between Mario and Clara has been validly terminated, Mario and Juana can freely marry each other. Letter B. The Renwa Doctrine is relevant in cases where one country applies the domiciliary theory and the other the nationality theory, and the issue involved is which of the laws of the two countries should apply to determine the other order of succession, the amount of successional rights, or the intrinsic validity of testamentary provision. Such issue is not involved in this case. Q. Juan is a Filipino citizen residing in Tokyo, Japan. State what laws govern his capacity to contract marriage in Japan, his successional rights as regard his deceased Filipino father property in Texas, USA, the intrinsic validity of the last will and testament which Juan executed while sojourning in Switzerland, the intrinsic validity of said will. Answer. Number 1. One's capacity to contract marriage is governed by the Philippine law, the Family Code, pursuant to Article 15 Civil Code, which provides that our laws relating to, among others, legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Number 2. By way of exception to the general rule of lex veracite prescribed by the first paragraph of Article 16 Civil Code, a person's successional rights are governed by the national law of the decedent, second paragraph, Article 16. Since one's deceased father was a Filipino citizen, Philippine law governs one's successional rights. 3. The extrinsic validity of one's will is governed by A. Swiss law, it being the law where the will was made, Article 17, first paragraph, Civil Code, or B. Philippine law, by implication from the provisions of Article 816 Civil Code, which allows even an alien who is abroad to make a will in conformity with our Civil Code. Number 4. The intrinsic validity of his will is governed by Philippine law, it being his national law, Article 16, Civil Code. Q. Francis Albert, a citizen and resident of New Jersey, USA, under whose law he was still a minor, being only 20 years of age, was hired by ABC Corporation of Manila to serve for 2 years as its chief computer programmer. But after serving for only 4 months, he resigned to join XYZ Corporation, which enticed him by offering more advantageous terms. His first employer sues him in Manila for damages arising from the breach of his contract of employment. He sets up his minority as a defense and asks for annulment of the contract on that ground. The plaintiff disputes this by alleging that since the contract was executed in the Philippines, under whose law the age of majority is 18 years old, he was no longer a minor at the time of perfection of the contract. Will the suit prosper? A. The suit will not prosper. Under Article 15 Civil Code, New Jersey law governs Francis Albert's capacity to act, being his personal law from the standpoint of both his nationality and his domicile. He was therefore a minor at the time he entered into the contract. Q. Alex was born a Filipino but was a naturalized Canadian citizen at the time of his death on December 25, 1998. He left behind a last will and testament in which he bequeathed all his properties, real and personal, in the Philippines to his acknowledged illegitimate Filipino daughter and nothing to his 2 legitimate Filipino sons. The sons sought the annulment of the last will and testament on the ground that it deprived them of their legitimes, but the daughter was able to prove that there were no compulsory heirs or legitimes under Canadian law. Who should prevail? Why? Answer. The daughter should prevail because Article 16 of the new Civil Code provides that intestate and testamentary succession shall be governed by the national law of the person whose succession is under consideration. Q. Felipe and Felisa, both Filipino citizens, were married in Malolos, Bulacan on June 1, 1950. In 1960, Felipe went to the United States, becoming a U.S. citizen in 1975. In 1980, he obtained a divorce from Felisa, who was duly notified of the proceedings. The divorce decree became final under California law. Coming back to the Philippines in 1982, Felipe married Segundina, a Filipino citizen. In 2001, Felipe, then domiciled in Los Angeles, California, died, leaving 1 child by Felisa and another one by Segundina. He left a will which was executed in Manila, under which he left his estate to Segundina and his 2 children and nothing to Felisa. Segundina files a petition for the probate of Felipe's will. Felisa questions the intrinsic validity of the will, arguing that her marriage to Felipe subsisted despite the divorce obtained by Felipe because said divorce is not recognized in the Philippines. For this reason, she claims that the properties left by Felipe are their conjugal properties and that Segundina has no successional rights. A. Is the divorce secured by Felipe in California recognizable and valid in the Philippines? How does it affect Felipe's marriage to Felisa? Explain. B. What law governs the formalities of the will? Explain. C. Will Philippine law govern the intrinsic validity of the will? Explain. Answer. of number 1. The divorce secured by Felipe in California is recognizable and valid in the Philippines because he was no longer a Filipino at the time he secured it. Aliens may obtain divorce abroad, which may be recognized in the Philippines provided that they are valid according to their national law. Van Dorn versus Romilo Jr. Number 2. With respect to Felipe, the divorce is valid, but with respect to Felisa, it is not. The divorce will not capacitate Felisa to remarry because she and Felipe were both Filipino at the time of their marriage. However, in DOJ Opinion Number 134, Series of 1993, Felisa is allowed to remarry because the injustice sought to be corrected by Article 26 also obtains in her case. Letter B. The foreigner who executes his will in the Philippines may observe the formalities prescribed in number 1. The law of the country of which he is a citizen under Article 817 of the New Civil Code, or the law of the Philippines being the law of the place of execution under Article 17 of the New Civil Code. Letter C. Philippine law will not govern the intrinsic validity of the will. Article 16 of the New Civil Code provides that intrinsic validity of testamentary provisions shall be governed by the national law of the person whose succession is under consideration. California law will govern the intrinsic validity of the will. Q. Felipe is a Filipino citizen. When he went to Sydney for vacation, he met a former business associate who proposed to him a transaction which took him to Moscow. Felipe brokered a contract between Sydney Coals Corporation, Coals, an Australian firm, and Moscow Energy, a Russian firm, for Coals to supply coal to Energy on a monthly basis for 3 years. Both these firms were not doing and still not doing business in the Philippines. Felipe shuttled between Sydney and Moscow to close the contract. He also executed in Sydney a commission contract with Coals and in Moscow with Energy, under which contract he was guaranteed commissions by both firms based on a percentage of deliveries for the 3-year period, payable in Sydney and in Moscow, respectively, through deposits in accounts that he opened in the 2 cities. Both firms paid Felipe his commission for 4 months, after which they stopped paying him. Felipe learned from his contacts, who are residents of Sydney and Moscow, that the 2 firms talked to each other and decided to cut him off. He now filed suit in Manila against both Coals and Energy for specific performance. A. Define or explain the principle of lex loci contractus. B. Define or explain the rule of forum nonconvenience. C. Should the Philippine court assume jurisdiction over the case? Explain. Answer to letter A. It is the law of the place where contracts, wills, and other public instruments are executed and governs their form and solemnities pursuant to the first paragraph, Article 17 of the New Civil Code. Or, number 2, it is the proper law of the contract, the system of law intended to govern the entire contract, including its essential requisites, indicating the law of the place with which the contract has its closest connection, or where the main elements of the contract converge, as illustrated by Salamea v. Court of Appeals. It is the law of the place where the airline ticket was issued, where the passengers are nationals and residents of, and where the defendant airline company maintained its office. Letter B. Forum nonconvenience means that a court has discretionary authority to decline jurisdiction over cause of action when it is of the view that the action may be justly and effectively adjudicated elsewhere. Letter C. No, the Philippine courts cannot acquire jurisdiction over the case of Felipe. Firstly, under the rule of forum nonconvenience, the Philippine court is not a convenient forum as all the incidents of the case occurred outside the Philippines. Neither are both Coals and Energy doing business inside the Philippines. Secondly, the contracts were not perfected in the Philippines. Under the principle of lex loci contractus, the law of the place where the contract is made shall apply. Lastly, the Philippine court has no power to determine the facts surrounding the execution of said contract. And even if a proper decision could be reached, such would have no binding effect on Coals and Energy, as the court was not able to acquire jurisdiction over the said corporations. Q. Jean and Jane, Filipinos, met and got married in England while both were taking up postgraduate courses there. A few years after their graduation, they decided to annul their marriage. Jane filed an action to annul her marriage to Jean in England on the ground of the latter's sterility, a ground for annulment of marriage in England. The English court decreed the marriage annulled. Returning to the Philippines, Jean asked you whether or not he would now be free to marry his former girlfriend. What would your legal advice be? Answer: no, Gene is not free to marry his former girlfriend. His marriage to Jane, if valid according to the forms and solemnities of British law, is valid here. Article 17, first paragraph. However, since Jean and Jane are still Filipinos, although living in England, the dissolution of their marriage is still governed by Philippine law. Since sterility is not one of the grounds for the annulment of marriage under Article 45 of the Family Code, the annulment of Jean's marriage to Jane on that ground is not valid in the Philippines. Q. PH and LV are HK. Chinese, Hong Kong Chinese. Their parents are now Filipino citizens who live in Manila. While still students in MNS state, they got married, although they are first cousins. It appears that both in Hong Kong and MNS state, first cousins could marry legally. They plan to reside and set up business in the Philippines, but they have been informed, however, that marriage of first cousins here is considered void from the beginning by reason of public policy. They are in a dilemma. They don't want to break Philippine law, much less their marriage vow. They seek your advice on whether their civil status will be adversely affected by Philippine domestic law. What is your advice? Letter B. In a class suit for damages, plaintiff claimed they suffered injuries from torture during martial law. The suit was filed upon President EM's arrival on exile in Hawaii, a U.S. state. The court in Hawaii awarded plaintiff the equivalent of $100 billion under the U.S. law on alien tort claims. On appeal, EM's state raised the issue of prescription. It argued that since said U.S. law is silent on the matter, the court should apply: number 1, Hawaii's law setting a 2-year limitation on tort claims, or Philippine law, which appears to require that claims for personal injury arising from martial law be brought within 1 year. Plaintiff countered that provision of the most analogous federal statute, the Torture Victims Protection Act, should be applied. It sets 10 years as a period for prescription. Moreover, they argued that equity could toll the state statute of limitation, for it appeared that EM had procured constitutional amendments granting himself and those acting under his direction immunity from suit during his tenure. In this case, has prescription set in or not? Considering the differences in the cited laws, which prescriptive period should be applied? 1 year under Philippine law, 2 years under Hawaii law, 10 years under U.S. federal law, or none of the above? Answer. The civil status of PH and LV will not be adversely affected by Philippine laws because they are nationals of Hong Kong and not Filipino citizens. Being foreigners, their status, conditions, and legal capacity in the Philippines are governed by the law of Hong Kong and the country of which they are citizens. Since their marriage is valid under Hong Kong law, it shall be valid and respected in the Philippines. B. The U.S. court should apply U.S. law, the law of the forum, in determining the applicable prescriptive period. While U.S. law is silent on this matter, the U.S. court will not apply Philippine law in determining the prescriptive period. It is generally affirmed as a principle in private international law that procedural law is one of the exceptions to the application of foreign law by the forum, since prescription is a matter of procedural law even in Philippine jurisprudence. The U.S. court will apply either Hawaii or federal law in determining the applicable prescriptive period and not Philippine law. The restatement of American law affirms this principle. Q. A Filipino couple, Mr. and Mrs. B.M. Jr., decided to adopt YV, an orphan from St. Clair's Orphanage in New York City. They loved and treated her like a legitimate child, for they have none of their very own. However, B.M. Jr. died in an accident at sea, followed to the grave a year later by his sick father, B.M. Sr. Each left a sizable estate consisting of bank deposits, lands, and buildings in Manila. May the adopted child YV inherit from B.M. Jr.? May she also inherit from B.M. Sr.? Is there a difference? Why? Explain. Mr. XT and Mrs. YT have been married for 20 years. Suppose the wife, YT, died childless, survived only by her husband, XT. What would be the share of XT from her estate as inheritance? Why? Explain. Answer. Letter A. YV can inherit from B.M. Jr. The succession to the estate of B.M. Jr. is governed by the Philippine law because he was a Filipino when he died. Article 16 Civil Code. Under Article 1039 of the Civil Code, the capacity of the heir to succeed is governed by the national law of the decedent and not by the national law of the heir. Hence, whether or not YV can inherit from B.M. Jr. is determined by Philippine law. Under Philippine law, the adopted inherit inherits from the adopter as a legitimate child of the adopter. YV, however, cannot inherit in his own right from the father of the adopter, BM Sr., because he is not a legal heir of BM Sr. The legal fiction of adoption exists only between the adopted and the adopter. Teocido versus Del Val. Neither may he inherit from BM Sr. by representing BM Jr., because in representation, the representative must be a legal heir not only of the person he is representing, but also the descendant from whom the represented was supposed to inherit. Article 973. Letter B. Answer. Under the Civil Code, the widow or widower is a legal and compulsory heir of the deceased spouse. If the widow is the only surviving heir, there being no legitimate descendants, brothers and sisters, nephews and nieces, she gets the entire estate. Q. Bonnie and Anne met while working overseas. They became sweethearts and get engaged to be married on New Year's Eve aboard a cruise ship in the Caribbean. They took the proper license to marry in New York City, where there is a Filipino consulate, but as planned, the wedding ceremony was officiated by the captain of the Norwegian registered vessel in a private suite among selected friends. Back in Manila, Anne discovered that Bonnie had been married in Bacolod City 5 years earlier, but divorced in Oslo only last year. His first wife was also a Filipina but now based in Sweden. Bonnie himself is a resident of Norway, where he and Anne plan to live permanently. Anne retains her services to advise her on whether her marriage to Bonnie is valid under Philippine law. Is there anything else she should do under the circumstances? B. In his lifetime, a Pakistani citizen, Adil, married 3 times under Pakistani law. When he died an old widower, he left behind 6 children, 2 sisters, 3 homes, and an estate worth at least 30 million pesos in the Philippines. He was born in Lahore but last resided in Cebu City, where he had a mansion and where 2 of his youngest children now live and work. 2 of his oldest children are farmers in Sulu, while the 2 middle-aged children are employees in Zamboanga City. Finding that the deceased left no will, the youngest son wanted to file intestate proceeding before the Regional Trial Court of Cebu City. 2 other siblings objected, arguing that it should be in Holo before a Sharia court, since his lands are in Sulu. But Adil's sister in Pakistan want the proceedings held in Lahore before a Pakistani court. Which court has jurisdiction and is the proper venue for the intestate proceeding? The law of which country shall govern succession to his estate? Answer to letter A. If Bonnie is still a Filipino citizen, his legal capacity is governed by Philippine law, Article 15 Civil Code. Under the Philippine law, his marriage to Anne is void because of prior existing marriage which was not dissolved by the divorce decreed in Oslo. Divorce obtained abroad by Filipino is not recognized. If Bonnie was no longer a Filipino citizen, the divorce is valid. Hence, his marriage to Anne is valid if celebrated in accordance with the law of the place where it was celebrated. Since the marriage was celebrated aboard a vessel of Norwegian registry, Norwegian law applies. If the ship captain has authority to solemnize the marriage aboard his ship, the marriage is valid and shall be recognized in the Philippines. As to the second question, if Bonnie is still a Filipino, Anne can file an action for a declaration of nullity of her marriage to him. B. Insofar as the properties of the decedent located in the Philippines are concerned, they are governed by the Philippine law. Under the Philippine law, the proper venue for the settlement of the estate is the domicile of the decedent at the time of his death. Since the decedent last resided in Cebu City, that is the proper venue for the intestate settlement of his estate. However, the successional rights to the estate of Adil are governed by Pakistani law, his national law, under Article 16 of the Civil Code. Q. In 1985, Sonny and Lulu, both Filipino citizens, were married in the Philippines. In 1987, they separated, and Sonny went to Canada, where he obtained a divorce in the same year. He then married another Filipina, Auring, in Canada on January 1, 1988. They had 2 sons, James and John. In 1990, after failing to hear from Sonny, Lulu married Tirso, by whom she had a daughter, Verna. In 1991, Sonny visited the Philippines, where he succumbed to heart attack. Discuss the effect of the divorce obtained by Sonny and Lulu in Canada. Explain the status of the marriage between Sonny and Auring. Answer. Letter A. The divorce obtained by Sonny in Canada was not valid because he and his wife were both Filipino citizens. Divorce between a Filipino couple is not valid under Philippine law even though they are living abroad. Letter B. Since the divorce obtained by Sonny was void, his marriage to Oring is necessarily void ab initio because of his subsisting marriage to Lulu. Q. Roberta, a Filipino 17 years of age, without the knowledge of his parents, can acquire a house in Australia because Australian laws allow aliens to acquire property from the age of 16. Answer. True. Since Australian law allows alien to acquire property from the age of 16, Roberta may validly own a house in Australia, following the principle of lex recite enshrined in Article 16, which states real property as well as personal property is subject to the law of the country where it is situated. Moreover, even assuming that the legal capacity of Roberta in entering the contract in Australia is governed by Philippine law, she will acquire ownership over the property both until the contract is annulled. Q. Emmanuel and Margarita, American citizens and employees of the U.S. State Department, got married in the African state of Kenya, where sterility is ground for annulment of marriage. Thereafter, the spouses were assigned to the U.S. Embassy in Manila. On the first year of the spouse's tour of duty in the Philippines, Margarita filed an annulment case against Emmanuel because the Philippine court on the ground of her husband's sterility at the time of the celebration of their marriage. Will the suit prosper? Explain your answer. Answer is no. The suit will not prosper. As applied to foreign nationals with respect to family relations and status of persons, the nationality principle set forth in Article 15 will govern the relationship of Emmanuel and Margarita. Since they are American citizens, the governing law as to the ground for annulment is not Kenyan law, which Margarita invokes in support of sterility as such ground, but should be U.S. law, which is the national law of both Emmanuel and Margarita, as recognized under Philippine law. Hence, the Philippine court will not give due course to the case based on Kenyan law. The nationality principle, as expressed in the application of national law of foreign nationals by Philippine court, is established by precedent. Q. If Gaya, a Filipino citizen residing in the United States, files a petition for change of name before the District Court of New York, what law shall apply? Answer. New York law shall apply. The petition of change of name filed in New York does not concern the legal capacity or status of the petitioner. Moreover, it does not affect the registry of any other country, including the country of birth of the petitioner. However, whatever judgment is rendered in that petition will have effect only in New York. The New York court cannot, for instance, order the civil register in the Philippines to change its records. The judgment of the New York court allowing a change in the name of the petitioner will be limited to the records of the petitioner in New York and use of her new name in all transactions in New York. Since the records and processes in New York are the only ones affected, the New York court will apply New York law in resolving the petition. Q. The doctrine of processual presumption allows the court of the forum to presume that the foreign law applicable to the case is the same as the local or domestic law. Answer. True. If the foreign law necessary to resolve an issue is not proven as a fact, the court of the forum may presume that the foreign law is the same as the law of the forum. Q. On December 1, 2000, Dr. Juanito Fuentes executed a holographic will, wherein he gave nothing to his recognized illegitimate son Jay. Dr. Fuentes left for the United States, passed the New York medical licensure examinations, resided therein, and became a naturalized American citizen. He died in New York in 2007. The laws of New York do not recognize holographic wills or compulsory heirs. Can the holographic will of Dr. Fuentes be admitted to probate in the Philippines? Why or why not? Assuming that the will is probated in the Philippines, can Jay validly insist that he be given his legitim? Why or why not? Answer. Letter A. Yes, the holographic will of Dr. Fuentes may be admitted to probate in the Philippines because there is no public policy violated by such probate. The only issue at probate is the due execution of the will, which includes the formal validity of the will. As regards formal validity, the only issue the court will resolve at probate is whether or not the will was executed in accordance with the form prescribed by the law observed by the testator in the execution of his will. For purposes of probate in the Philippines, an alien testator may observe the law of the place where the will was executed, Article 17. or the formalities of the law of the place where he resides, or according to the formalities of the law of his own country, or in accordance with the Philippine Civil Code, Article 816. Since Dr. Fuentes executes his will in accordance with the Philippine law, the Philippine court shall apply the new civil code in determining the formal validity of the holographic will. The subsequent change in the citizenship of Dr. Fuentes did not affect the law governing the validity of his will. Under the new civil code, which was the law used by Dr. Fuentes, the law enforced at the time of execution of the will shall govern the formal validity of the will. Letter B. No, J cannot insist because under New York law, he is not a compulsory heir entitled to a legitime. The national law of the testator determines who his heirs are and the order that they succeed, how much their successional rights are, and whether or not a testamentary disposition in his will is valid. Article 16. Since Dr. Fuentes was a U.S. citizen, the laws of the New York determines who his heirs are. And since the New York law does not recognize the concept of compulsory heirs, J is not a compulsory heir of Dr. Fuentes entitled to a legitime. Q. Ted, married to Annie, went to Canada to work. 5 years later, Ted became a naturalized Canadian citizen. He returned to the Philippines to convince Annie to settle in Canada. Unfortunately, Ted discovered that Annie and his friend Louis were having an affair. Deeply hurt, Ted returned to Canada and filed a petition for divorce, which was granted. In December 2013, Ted decided to marry his childhood friend, Corazon, in the Philippines. In preparation for the wedding, Ted went to the local civil registry of Quezon City, where his marriage contract with Annie was registered. He asked the civil register to annotate the decree of divorce in his marriage contract with Annie. However, he was advised by the National Statistics to file a petition for judicial recognition of the decree of divorce in the Philippines. Is it necessary for Ted to file a petition for judicial recognition of the decree of divorce he obtained in Canada before he can contract a second marriage in the Philippines? Answer. Yes. A divorce decree, even if validly obtained abroad, cannot have effect in the Philippines unless it is judicially recognized through an appropriate petition filed before the Philippine courts. The foreigner must file a petition under Rule 108 and prove therein the fact of divorce by presenting an official copy attested by the officer having custody of the original. He must also prove that the court which issued the divorce has jurisdiction to issue it, and the law of the foreign country on divorce, Corpus versus Santo Tomas. Human Relations, Article 19 to 22, Civil Code. Q. Rosa was leasing an apartment in the city. Because of the rent control law, her landlord could not increase the rental as much as he wanted to, nor terminate her lease as long as she was paying her rent. In order to force her to leave the premises, the landlord stopped making repairs on the apartment and caused the water and electricity services to be disconnected. The difficulty of living without electricity and running water resulted in Rosa suffering a nervous breakdown. She sued the landlord for actual and moral damage. Will the action prosper? Explain. Answer: yes. Based on quasi-delict under Human Relations provision on the new Civil Code, Article 19, 20, and 21, because the act committed by the lessor is contrary to morals, moral damages are recoverable under Article 2219, number 10, in relation to Article 21. Although the action is based on quasi-delict and not on contract, actual damages may be recovered if the lessee is able to prove the losses and expenses she suffered. Q. Ricky donated $1 million to the unborn child of his pregnant girlfriend, which she accepted. After 6 months of pregnancy, the fetus was born and baptized as Angela. However, Angela died 20 hours after birth. Ricky sought to recover the $1 million. Is Ricky entitled to recover? Explain. Answer: yes. Ricky is entitled to recover the $1 million. NCC considers a fetus a person for purposes favorable to it, provided it is born later in accordance with the provision of the new CC. While the donation is favorable to the fetus, the donation did not take effect because the fetus was not born in accordance with the new Civil Code. To be considered born, the fetus that had an uterine life of less than 7 months should live for 24 hours from its complete delivery from the mother's womb. Since Angela had an intrauterine life of less than 7 months but did not live for 24 hours, she was not considered born and therefore did not become a person. Article 41. Not being a person, she has no juridical capacity to be a donee, hence the donation to her did not take effect. The donation not being effective, the amount donated may be recovered. To retain it will be unjust enrichment. Q. Isidro and Irma, Filipinos, both 18 years of age, were passengers of flight number 317 of Oriental Airlines. The plane they boarded was of Philippine registry. While en route from Manila to Greece, some passengers hijacked the plane, held the chief pilot hostage at the cockpit and ordered him to fly instead to Libya. During the hijacking, Isidro suffered a heart attack and was on the verge of death. Since Irma was already 8 months pregnant by Isidro, she pleaded to the hijackers to allow the assistant pilot to solemnize her marriage with Isidro. Soon after the marriage, Isidro expired. As the plane landed in Libya, Irma gave birth. However, the baby died a few minutes after complete delivery. Back in the Philippines, Irma immediately filed a claim for inheritance. The parents of Isidro opposed to her claim, contending that the marriage between her and Isidro was void ab initio on the following grounds. They had not given their consent to the marriage of their son. There was no marriage license. The solemnizing officer had no authority to perform the marriage, and the solemnizing officer did not file an affidavit of marriage with the proper civil register. Does Irma have any successional rights at all? Discuss fully. Answer. Irma succeeded to the estate of Isidro as his surviving spouse to the estate of her legitimate child. When Isidro died, he was succeeded by his surviving wife Irma and his legitimate unborn child. They divided the estate equally between them, the child excluding the parents of Isidro. The unborn child is considered born for all purposes favorable to it, provided it be born later. The child was considered born because, having an intrauterine life of more than 7 months, it lived for a few minutes after its complete delivery. It was legitimate because it was born within the valid marriage of the parents. Succession is favorable to it. When the child died, Irma inherited the share of the child. However, the share of the child in the hands of Irma is subject to reserva truncal for the benefit of the relatives of the child within the 3rd degree of consanguinity and who belong to the line of Isidro. Q. Jamie, who is 65, and his son, Willie, who is 25, died in a plane crash. There is no proof as to who died first. Jamie's only surviving heir is his wife, Julia, who is also Willie's mother. Willie's surviving heir are his mother, Julia, and his wife, Wilma. In the settlement of Jamie's estate, can Wilma successfully claim that her late husband, Willie, had a hereditary share since he was much younger than his father and therefore should be presumed to have survived longer? Suppose Jamie had a life insurance policy with his wife Julia and his son Willie as the beneficiaries. Can Wilma successfully claim that 1/2 of the proceeds should belong to Willie's estate? Answer. Number 1. No. Wilma cannot successfully claim that Willie had a hereditary share in his father's estate. Under Article 43 Civil Code, 2 persons who are called to succeed each other are presumed to have died at the same time in the absence of proof as to which of them died first. This presumption of simultaneous death applies in cases involving the question of succession as between the two who died, who in this case are mutual heirs, being father and son. Number 2. Yes, Wilma can invoke the presumption of survivorship and claim that 1/2 of the proceeds should belong to Willie's estate under Section 3, letter JJ, paragraph 5, Rule 131 of Rules of Court, as the dispute does not involve succession. Under this presumption, the person between the ages of 15 and 60 years is deemed to have survived one whose age was over 60 at the time of their death. The estate of Willie endowed with juridical personality stands in place instead of Willie as beneficiary. Q. Elated that her sister, who had been married for 5 years, was pregnant for the first time, Alma donated 100,000 to the unborn child. Unfortunately, the baby died 1 hour after delivery. May Alma recover the 100,000 that she had donated to said baby before it was born, considering that the baby died? State otherwise. Is the donation valid and binding? The donation is valid and binding, being an act favorable to the unborn child, but only if the baby had an intrauterine life of not less than 7 months, and provided there was due acceptance of the donation by the proper person representing the said child. If the child has had less than 7 months of intrauterine life, it is not deemed born, since it died less than 24 hours following its delivery, in which case the donation never became effective, since the donee never became a person, birth being determinative of personality. Q. Mr. and Mrs. Cruz, who are childless, met with a serious motor vehicle accident with Mr. Cruz at the wheel and Mrs. Cruz seated beside him, resulting in the instant death of Mr. Cruz. Mrs. Cruz was still alive when help came, but she also died on the way to the hospital. The couple acquired properties worth 1 million during their marriage, which are being claimed by the parents of both spouses in equal shares. Is the claim of both sets of parents valid, and why? Suppose in the preceding question both Mr. and Mrs. Cruz were already dead when help came, so that nobody could say who died ahead of the other. Would your answer be the same to the questions as to who are entitled to the properties of the deceased couple? Answer to letter A. No. The claim of both parents is not valid. When Mr. Cruz died, he was succeeded by his wife and his parents as his estate heirs who will share his estate equally. His estate was 0.5 million pesos, which is his half share in the absolute community, amounting to 1 million pesos. His wife will therefore inherit 0.25 million pesos, and his parents will inherit 0.25 million pesos. When Mrs. Cruz died, she was succeeded by her parents as her intestate heirs. They will inherit all of her estate, consisting of 0.5 million. Half share is the absolute community, and her 25 million inheritance from her husband, or a total of 0.75 million pesos. In sum, the parents of Mr. Cruz will inherit 250,000 pesos, while the parents of Mrs. Cruz will inherit 750 pesos. B. This being a case of succession, in the absence of proof as to the time of death of each of the spouses, it is presumed they died at the same time, and no transmission of rights from one to the other is deemed to have taken place. Therefore, each of them is deemed to have an estate valued at 500,000, or half of their conjugal property of 1 million. The respective parents will thus inherit the entire 1 million in equal shares, or 500,000 per set of parents. Q. Mr. Luna died, leaving an estate of 10 million pesos. His widow gave birth to a child 4 months after Mr. Luna's death, but the child died 5 hours after birth. 2 days after the child's death, the widow of Mr. Luna also died because she had suffered from difficult childbirth. The estate of Mr. Luna is now being claimed by his parents and the parents of his widow. Who is entitled to Mr. Luna's estate, and why? Answer. Half of the estate of Mr. Luna will go to the parents of Mrs. Luna as their inheritance from Mrs. Luna, while the other half will be inherited by the parents of Mr. Luna as the reservatorius of the reserved property inherited by Mrs. Luna from her child. When Mr. Luna died, his heirs were his wife and the unborn child. The unborn child inherited because the inheritance was favorable to it, and it was born alive later, though it lived only for 5 hours. Mrs. Luna inherited half of the 10 million, while the unborn child inherited the other half. When the child died, it was survived by its mother, Mrs. Luna, as the only heir. Luna inherited by operation of law the estate of the child, consisting of 5 million inheritance from Mr. Luna. In the hands of Mrs. Luna, what she inherited from her child was subject to reserva for the benefit of the relatives of the child within the 3rd degree of consanguinity, and who belonged to the family of Mr. Luna, the line where the property came from. When Mrs. Luna died, she was survived by her parents as her only heirs. Her parents will inherit her estate, consisting of 5 million she inherited from Mr. Luna. The other 5 million she inherited from her child will be delivered to the parents of Mr. Luna as beneficiaries of the reserved property. In sum, 5 million pesos of Mr. Luna's estate will go to the parents of Mrs. Luna, while the other 5 million pesos will go to parents of Mr. Luna as reservatorios. Q. Christy and her late husband, Luis, had 2 children, Rose and Patrick. One summer, her mother-in-law, aged 70, took the 2 children, then aged 10 and 12, with her on a boat trip to Cebu. Unfortunately, the vessel sank en route, and the bodies of the 3 were never found. None of the survivors ever saw them on the water. On the settlement of her mother-in-law's estate, Christie files a claim for a share of her estate on the ground that the same was inherited by her children from their grandmother in representation of their father, and she inherited the same from them. Will her action prosper? Answer: no. Her action will not prosper, since there was no proof as to who died first. All the three are deemed to have died at the same time, and there was no transmission of rights from one to another. Applying Article 43 of the NCC. Q. If a pregnant woman passenger of a bus were to suffer an abortion following a vehicular accident due to the gross negligence of the bus driver, may she and her husband claim damages from the bus company for the death of their unborn child? Explain. Answer: no. The spouses cannot recover actual damages in the form of indemnity for the loss of life of the unborn child. This is because the unborn child is not yet considered person, and the law allows indemnity only for loss of life of person. The mother, however, may recover damages for the bodily injury she suffered from the loss of the fetus, which is considered part of her internal organ. The parents may also recover damages for injuries that are inflicted directly upon them. Example: moral damages for mental anguish that attended the loss of the unborn child. Since there is gross negligence, exemplary damages can also be recovered. Gelus versus CA, GR 16439. At the age of 18, Marian found out that she was pregnant. She insured her own life and named her unborn child as her sole beneficiary. When she was already due to give birth, she and her boyfriend Pietro, the father of her unborn child, were kidnapped in a resort in Bataan, where they were vacationing. The military gave chase, and after 1 week, they were found in an abandoned hut in Cavite. Marian and Pietro were hacked with bolos. Marian and the baby were both found dead, with the baby's umbilical cord already cut. Pietro survived. Can Marian's baby be the beneficiary of the insurance taken on the life of the mother? Between Marian and the baby, who is presumed to have died ahead, will Pietro, a surviving biological father of the baby, be entitled to claim the proceeds of the life insurance on the life of Marian? Answer: yes. The baby can be the beneficiary of the life insurance of Marian. Article 40 of the Family Code provides that birth determines personality, but the conceived child shall be considered born for all purposes that are favorable to it, provided it be born later with the conditions specified in Article 41. Article 41 states that for civil purposes the fetus shall be considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. The act of naming the unborn child as sole beneficiary in the insurance is favorable to the conceived child, and therefore the fetus acquires presumptive or provisional personality. However, said presumptive personality only becomes conclusive if the child is born alive. The child need not survive for 24 hours as required under Article 41 of the Code, because Marian was already due to give birth, indicating that the child was more than 7 months old. B. If the baby was not alive when completely delivered from the mother's womb, it was not born as a person, then the question of who between two persons survived will not be an issue. Since the baby had an intrauterine life of more than 7 months, it would be considered born if it was alive at the time of its complete delivery from the mother's womb. We can gather from the facts that the baby was completely delivered, but whether or not it was alive has to be proven by evidence. If the baby was alive when completely delivered from the mother's womb, then it was born as a person, and the question of who survived as between the baby and the mother shall be resolved by the provisions of the rules of court on survivorship. This is because the question has nothing to do with succession. Obviously, the resolution of the question is needed just for the implementation of an insurance contract. Under Rule 13, Section 3, JJ, Number 5, as between the baby, who was under 15 years old, and Marian, who was 18 years old, Marian is presumed to have survived. In both cases, therefore, the baby never acquired any right under the insurance policy. The proceeds of the insurance will then go to the estate of Marian. Since the baby did not acquire any right under the insurance contract, there is nothing for Pietro to inherit. Q. Dr. Lopez, the 70-year-old widower, and his son Roberto both died in a fire that gutted their house while they were sleeping in their air-conditioned room. Roberto's wife, Marilyn, and their 2 children were spared because they were in the province at the time. Dr. Lopez left an estate worth $20 million and a life insurance policy in the amount of $1 million with his 3 children. one of whom is Roberto, as beneficiaries. Marilyn is now claiming for herself and her children her husband's share in the estate left by Dr. Lopez and her husband's share in the proceeds of Dr. Lopez's life insurance policy. Rule on the validity of Marilyn's claims with reason. As to the estate of Dr. Lopez, Marlene is not entitled to a share in the estate of Dr. Lopez. For purposes of succession, Dr. Lopez and his son Roberto are presumed to have died at the same time, there being no evidence to prove otherwise, and there shall be no transmission of rights from one to the other. Hence, Roberto inherited nothing from his father that Marlene would in turn inherit from Roberto. The children of Roberto, however, will succeed their grandfather, Dr. Lopez, in representation of their father, Roberto, and together will receive 1/3 of the estate of Dr. Lopez, since their father, Roberto, was one of the 3 children of Dr. Lopez. Marlene cannot represent her husband, Roberto, because the right is not given by law to a surviving spouse. As to the proceeds of the insurance on the life of Dr. Lopez, since succession is not involved as regard the insurance contract, the provisions of the rules of court on survivorships shall apply. Under the rules, Dr. Lopez, who was 70 years old, is presumed to have died ahead of Roberto, who is presumed lay between the ages of 15 and 60. Having survived the insured, Roberto's right as a beneficiary became vested upon the death of Dr. Lopez. When Roberto died after Dr. Lopez, his rights to receive the insurance proceeds became part of his hereditary estate, which in turn was inherited in equal shares by his legal heirs, namely his spouse and children. Therefore, Roberto's children and his spouse are entitled to Roberto's 1/3 share in the insurance proceeds. Q. Brad and Angelina had a secret marriage before a pastor whose office is located in Arroceros Street, City of Manila. They paid money to the pastor who took care of all the documentation. When Angelina wanted to go to the U.S., she found out that there was no marriage license issued to them before their marriage. Since their marriage was solemnized in 1995 after the effectivity of the family code, Angelina filed a petition for judicial declaration of nullity on the strength of a certification by the Civil Registrar of Manila that after a diligent and exhaustive search, the alleged marriage license indicated in the marriage certificate does not appear in the records and cannot be found. Decide the case and explain. In the case, the marriage was solemnized in 1980 before the effectivity of the family code. Is it required that a judicial petition be filed to declare the marriage null and void? Explain. Answer to number 1. I will grant the petition for judicial declaration of nullity of Brad and Angelina's marriage on the ground that there is a lack of marriage license. Article 3 of the Family Code provides that one of the formal requisites of marriage is a valid marriage license, and Article 4 of the same code states that absence of any of the essential or formal requisites shall render the marriage void ab initio. In Abbas versus Abbas, the Supreme Court declared the marriage as void ab initio because there is proof of lack of record of marriage license. The certification by the Civil Registrar of Manila that after diligent and exhaustive search, the alleged marriage license indicated in the marriage certificate does not appear in the records and cannot be found proves that the marriage of Brad and Angelina was solemnized without the requisite marriage license and is therefore void ab initio. The absence of the marriage license was certified to be the local civil registrar who is the official custodian of these documents and who is in the best position to certify as to the existence of these records. Also, there is a presumption of regularity in the performance of official duty. Republic versus CA. Answer to number 2. No, it is not required that a judicial petition be filed to declare the marriage null and void when said marriage was solemnized before the effectivity of the family code, as stated in the cases of People versus Mendoza. The old rule is that where a marriage is legal and void from its performance, no judicial is necessary to establish its invalidity. Alternative answer. Irrespective to when the marriage took place, other than for purposes of free marriage, no judicial action is necessary to declare a marriage absolute nullity. For other purposes such as but not limited to determination of heirship, legitimacy or illegitimacy of a child, settlement of estate, dissolution of property regime, or a criminal case for that matter, the court may pass upon the validity of marriage, even in a suit not directly instituted, to question the same so long as it is essential to the determination of the case. This is without prejudice to any issue that may arise in the case. When such need arises, a final judgment of declaration of nullity is necessary, even if the purpose is other than to remarry. The clause on the basis of a final judgment declaring such previous marriage void in Article 40 of the Family Code connotes that such final judgment need to be obtained only for purposes of free marriage. Ablasa versus Republic.